I know it's going to be reading the Holy Bible. Hey, friends, all good. It's better than good. It's great. It's Friday. Welcome back to Law and Legitimacy. It's Norman Mike. You know, Mike was having tech issues.
Yeah, you know me,
well,
baby.
Honest, folks, I bought this Focusrite thing. I've got the headset. I've got a plug-in microphone. I even changed microphones. And it's always something, which proves Alex Jones is right, because the deep state is going to interfere with everything. So, you know, today is a day, as Mike puts it, OJ meets his juicer. You know, I don't know. You know, the OJ Simpson is dead. And if that's not a throwback for those of us of a certain age, nothing is. Mike.
Yeah, I really wanted to talk about this just because of your career arc, Norm, as a criminal defense attorney. You know, the legend of OJ Simpson, and more particularly, nothing about his football playing days, but the legend that, you know, he beat the case, right, exists in my world. That is in a certain ubiquity, right, that I can't really describe. But I was, you know, and so for that reason, it felt as though the proper way to go about discussing this would be to just simply ask you, as an up-and-coming criminal defense attorney. This is in the mid-90s, right? And so as sort of a, maybe not even up-and-coming at that, where were you in your career? And then talk about sort of the cultural aspect of the OJ trial.
You know, I was a baby lawyer. You know, law is a career switch for me, as you know, Mike. I taught at a certain university, which shall go unnamed, taught moral and political philosophy, and then worked as a journalist for another number of years, and only became a lawyer when it was obvious to me that law was the linchpin to understanding how the world worked. And if I wanted to have an influence on the world, it would be through law. So I was practicing law in New Haven at the time of the murder. I was aware, obviously, of who O.J. Simpson was. Not so much because I was a professional football fan. I was working 15, 16, 17-hour days, 6, 7 days a week at that point to get on my feet in the law. So it's not like I had a lot of time to watch TV or follow sports. But on those occasions where I turned the television on, there was this guy from USC who I'd seen in the Rose Bowl, because even hardworking lawyers take January 1st off. And then there was this guy I saw leaping over chairs in airport terminals with a smile that could sell Helen of Troy a bra. You know, I mean, O.J. Simpson just had charisma. And there he was in the white Bronco going down, I don't know if it was Highway 5, but some interstate in Florida, being followed, as you see in the picture here on the screen, by a bevy of police cars. And David Bachman, a friend of mine in John Williams' law firm, this is how far back it goes, back when John Williams was trying 1983 civil rights cases, civil rights cases against alleging unreasonable force and false arrest against police
one
officers.
One hell of an interview that we have with John R. Williams.
He was my first mentor in the law, my first partner in the law. And so Bachman called me into the conference room and he said, OJ, he's on the run. You know, he killed someone. And we watched that white Bronco go down the street, followed by the police cars. And it's an image I'll never forget. It's one of those, do you know where you were when the towers were stuck at 9/11, on 9/11 moments? And so, you know, I didn't have a chance to watch much of the trial because I was a trial lawyer at the time and had trials of my own. But I remember being on trial in Bridgeport, Connecticut, the day the verdict was returned. And I walked into a convenience store to pick up something, a Diet Coke, knowing me. I've since given it up, but at the time I've drunk enough Diet Coke that if it really corroded your gut, I would have
the DC boy.
died years ago. You know, it may be that my sell-by date is momentarily one, you know, come sweet death, as the Bible says. But in any case, you know, I learned that he was acquitted.
Look, deep down, that is truly your issue with Trump, isn't it? Right? You have this weird resentment that he still goes hard for Diet Coke, and you've just given it up.
No, I have a weird resentment that he still A, goes hard, and B, his hair is better than mine. It's orange, you know. I mean, like, you know, the Donald's got charisma. I mean, now, you know, but in any case, you know, OJ had been acquitted, and I was stunned because I thought, hey, you know, his former wife, she's noodling on, in the house, and he looks in and he gets overcome with rage and jealousy, and, you know, next thing you know, murder. And so the motive seemed to explain it all to me. And I let it go at that. Juries were acquitted. I was jealous of Johnny Cochran. I was envious of F. Lee Bailey's skill and prominence at the bar in the country, and wishing that I could develop a career as successful as F. Lee Bailey's. And you know what? That wish must have found its way to him, because a number of years later, I met F. Lee Bailey. He was interviewing me to take over some work that he couldn't do because he had since been disbarred. And we had lunch at the Quinnipiac Club in Connecticut. And the next thing you know, I was hired to represent a very prominent man named James Irwin in Irwin's disputes up and down the East Coast. Irwin was an international businessman of fabulous wealth, who ultimately killed himself on his, I don't know if it was on one of the family farms, but he killed himself during a painful divorce. He got an adverse ruling from a from a family court judge, and the next thing you know, he wrote an angry letter. It took him 2 shots to the head to kill him. He was that thick-skulled. But Bailey and I became pretty good friends. We spent maybe 3-4 weeks a month of our life together under one roof, either at his home at that point in suburban Massachusetts or in various hotel suites, not rooms, people. I don't want to spread rumors. And, working on cases and talking about cases. And we talked a lot about the OJ case. And he was absolutely persuaded, Bailey was, that OJ was innocent, that he did not commit the murder.
That's fascinating to me.
Yeah, he tells a story about the dynamics on the defense team. He was part of the team, and you'll recall Lee's famous cross-examination of Mark Furman on use of the N-word, racism, and destroying Furman's credibility. That was F. Lee Bailey. He was the best fact trier that I ever met, and I've met a lot of very good lawyers in the course of my lifetime. And what I mean by that is he had an encyclopedic ability to master a complex record, and notwithstanding the amount he drank, it all hung together in his head. I remember one day sitting with a stack of deposition transcripts at the study I used in one of his homes, and he came walking in about 10 o'clock that morning with a big glass of something brown and alcoholic. I said, "Hey, Norm, you want a drink?" I said, "It's 10 o'clock in the morning. I might have one at after 8, but I'm a cheap drunk. I'll be wasted." "Alcohol is my fuel," he said. And so we fueled up and we plowed through stuff for the day. But Bailey tells the following story, that in the defense team, they had reached a conclusion that they had the case beat, that the jury was going to acquit. Johnny Cochran was an LA lawyer. He was lead counsel. And in every joint enterprise among lawyers, there has to be one guy who calls the balls and strikes, who says this is where the buck stops. And that guy in this case was F. Lee Bailey. So Bailey said, was Johnny Cochran. So Cochran's position was, we got this case won, but their primary concern as they started putting on evidence was whether they were going to lose another juror and have a mistrial. You'll recall Lance Ito, the trial judge in that case, became a thing, which was an abject failure of the trial process. Whenever a trial judge becomes the focus of attention, you know that something has gone wrong. It's like going to the World Series and you know the umpire's name. If that's the case, there's something wrong with the strike zone. So they knew they had the case won. They were going to present evidence of someone who looked like Bailey being present at the scene as the dogs howled and then running. And they didn't put that guy on. And I thought that was a tremendously gutsy move, because if that lookalike was in fact an exonerating witness, why wouldn't you put him on? Well, they wouldn't put him on because they were certain they had the case beat. And at the rate things were going, they might have lost another juror. And if they had lost another juror, there'd be a mistrial and the state would get to try it again. And in their view, the people of California so mishandled the case, they were certain they had it won. So from Bailey's perspective, notwithstanding the evidence of motive, jealousy, notwithstanding circumstantial evidence, there was no question in his mind that O.J. Simpson was innocent. People disagree. I've given a couple interviews on other shows already this morning where people are absolutely persuaded that that O.J. Simpson was guilty. And why? Not because they have direct evidence based on what they've seen. but because of the circumstantial evidence, largely because of motive. And this is one of these cases where motive may have dwarfed the actual evidence in the case. So, OJ's gone. The debate will continue.
It's kind of wild. I'm just realizing. So first of all, what I've got on the screen is one of our earliest, back June 8th, 2021. This was during our sort of OG podcast days. And Kevin Allen allowed us to reproduce an interview that you hosted and conducted with F. Lee Bailey, I think in April of 21. And so this is a pretty special episode because we start with sort of a reading from your blog, Norm, where you give a farewell to a legend, F. Lee Bailey. But the interview itself that we reproduce in episode number 32 is you and F. Lee Bailey. And you talk about
Go ahead and have it fired up. Sorry, folks, you're getting a real view of what goes on in a law office before 8:30 in the morning. We're filing motions in a criminal case. Yeah, go ahead and file.
Look at what number episode this is, Norm. And I also number 32, and we're talking about O.J. Simpson, whose Buffalo Bills jersey number was 32 as well. Just little weirdness going on this morning, but I did want to plug that because we've been doing pretty cool stuff for the last several years. So I'll have to make sure that the link still works on all this, but I'll go back and make sure to pull that from the archives and maybe reproduce that here on the YouTube.
And let's just pause for a moment and talk about an emerging theme on the show. At any moment in the United States, there are any given court date, I should say, there are any number of murder cases going on. That is, cases in which one individual is alleged to have wrongfully and with intent killed another person, murder. Most of those cases don't make national and international news, and OJ's did. It became a high-profile case infected with that viral sort of energy that draws everybody to it. And I'm always intrigued by why some cases attract our attention and others don't. OJ was a phenomenally talented athlete, a good actor, a good stand-up comic, a charismatic person. He had a glow about him. And yet this bright star in American life turned, at least allegedly, suddenly dark and did the worst thing imaginable. And it suggests to me that this is proof once again that we all know in some inchoate level that we are capable of the worst, each of us.
Yeah. But in terms of the cultural impact, this like I said at the beginning, my formative years were marked in some way, shape, or form by the legend that is the OJ trial, right? The white Bronco, the police chase, and the Black community, nearly all of my life has held this case up on the mantle of sort of cultural victories. But the sort of byline to that is, or the subheading, if you will, was this sort of braggadociousness that OJ.
Braggadocious. You heard it first on Law and Legitimacy. Right. The evolution. Where is Samuel Johnson? Where is Noah Webster? Where is the Oxford English Dictionary?
Here is it. But I mean,
that's a new word.
It was OJ beat the system, right? And there was, there was never any real, at least in my world, and all of this is sort of anecdotal, and based on just an amalgamation, there's another word for you, of conversations over the course of my life and just listening. But this I guess foregone conclusion that the truth of the situation would never be known, and therefore culturally we would hold this up as sort of a win for the Black community over sort of the white criminal justice system, irrespective of whether OJ actually did it or not. And that was even more reason for many people to take the position that, yeah, he did it, but he beat the case, kind of thing. And your narrative, Norm, what you're giving us this morning is really interesting. And what you talked about with F. Lee Bailey in that interview from a few years ago is the first time I've ever heard that side of it, right? From someone directly involved in the case. And so I think that what we can use right now is, we talked about we've talked about the George Floyd case as well, and that sort of stands as a similar there's a parallel to the OJ case and the George Floyd or the Derek Chauvin case in my mind. And I think we also made that parallel on in our episode number 32 way back. And I don't know what 20, 30, 40 years from now we will think about, but obviously Derek Chauvin didn't beat the case, right? if that means anything.
Well, I mean, the fact of the matter is, I mean, I'm still rattled by the Las Vegas murder, involving I guess his name was Houston earlier in the week. We'll never really know unless you're an eyewitness what actually occurred. And even if you're an eyewitness, you don't really know what occurs in a person's mind. I mean, the sort of explosive rage that caused that lawyer to kill is just inconceivable to me. But yet I imagine it's not something I can empathetically find my way to. But yet I suspect that each of us is capable of that if pressed in the right moments and under the right circumstances. And I think we know that. And I think that's why some cases draw our attention and become the national source of debate. In my cynical moments, I say we want the person punished because we don't want them to enjoy a reward for doing what we in our worst moments and fantasies wish we could do. I mean, if you've never wished someone dead, even playfully, there's something wrong with you. We all want to eliminate obstacles to our desires. But the cultural significance of these cases with respect to race and whatnot, that's a whole other matter. I'm reminded, as you spoke, Mike, of the notion that slavery is America's original sin. We made a compact that declared all men were equal, and then decided that black persons weren't men. And those chickens continue to come home to roost and haunt the American psyche. In the OJ case, you characterize it as a win for the black community when a black defendant was found not guilty by a white criminal justice system. In the Floyd case, a white cop engaged in largely textbook behavior with respect to a clearly disturbed black man, held him down too long and was convicted of murder, and the nation erupted. And it erupted over what was really basically a relatively routine standoff between a disturbed defendant and a cop. Race matters. The unconscious matters. What we wish for matters. Celebrityhood matters, and the sort of hopes and aspirations that we place on the shoulders of celebrities matter. But in any case, and the debate will go on as to O.J. Simpson. I look forward to tomorrow's newspapers and the Sunday New York.
Two parting observations here. I don't know what Buick was ever doing with a contract for police cruisers. Those are hideous and obviously terrible. And then Ford has absolutely fumbled the bag in reintroducing the Bronco. How could you mess that up? Look how gorgeous that thing is. Anyway, onward and upward.
Jalapeno Jack doesn't look like I see a different headline, so let's go to that and pivot instead. The Arizona Supreme Court ruling that could tip the scales in Biden's favor in November. So in Arizona, a state Supreme Court ruling has held largely that, based on, I think, an 1864 or 54 statute, abortion is soon to become all but illegal in Arizona, meaning only in cases in which I believe a mother's life is in danger could an abortion be justified. And the result is an obvious consequence of Dobbs versus Women's Health, a decision made about a year ago, in which the United States Supreme Court held that there is no federal right to abortion, that given the limited nature of federal authority, the right to determine who, when, and under what circumstances a woman can abort a fetus is to be determined by the states. And so Arizona has reached a determination that under its law passed years ago, there shall be no routine right to abortion. And this flies directly in the face of what women in Arizona want. Women in Arizona, many at least, want the right to abort, and it puts its finger right on the crosshairs of what I think this debate is really all about. If, as a matter of biology, all the material necessary to give a life is present at the moment of conception, life begins at conception. Now, see, the key my mind was causing things. Oh, now it's your end. I'm not even on my mind.
It's not even my end. That's you.
So life is a moment of conception as a proposition. We've got the desire of a woman who is alive to abort, making a decision that she wants to end that life. And then we have general prohibitions in the law saying that you cannot willfully take the life of another. Okay. If that's the case, then abortion is wrong under criminal law. You're taking another life willfully. So you have to finesse the issue somewhat and claim that some lives are lives that matter and some are lives that don't matter. And what's that fault line? Some talk about personhood. When cells develop enough complexity to become a person, then they matter. They acquire the rights of personhood. But until that point, they're mere tissue. And this then, reopens the old debate about whether we have souls, for example, and whether as entities we are simply matter and motion and no more than complexity, the complex aggregation of molecules, atoms, and the energy that attracts and interacts and holds them together, or whether there is something divine about us. Whether there is, or whether in the image of God we were created, whether there is a spark, as it were. I think of Michelangelo's painting on the roof of the ceiling of the Sistine Chapel, Adam's finger touching God's, and in that moment, the spark of life being transmitted from the unseen to the seen world. I don't know. These aren't scientific questions. These are mysteries that go to the very heart of what it is to be a human being. And so the abortion debate forces us to recognize the law's limitations in the presence of the awesome phenomena of human personhood and our inability to give a complete account of why there's a world rather than not and why there are persons rather than not.
Yeah, and the procedural history on in Arizona for this case and for the law in the books is really interesting to me. I was speaking with my own mother. This has been a couple of years.
Mother? I thought you were a test tube baby.
No. Immaculate conception.
Hi, my name is Bunsen Burner Mike. Yeah.
And I was talking to my mother about this issue in particular with respect to Roe, and this is before Dobbs. This is far before the Dobbs decision. But even then, I think that we lose sight as a country, organized as, a sort of confederation of states, a republic, that our state legislatures always have the power to create these laws. And the fact that the law in the books from 1864 was still active and the language was clear, and there was litigation in the early 70s that was basically suspended upon the Supreme Court's ruling in Roe v. Wade. I made the point to my mother that we don't even necessarily have to agree on a conception of life, or the definition of life under whatever. Every state and politicians have the ability, and individuals have the ability to organize and lobby to pass laws. Why was Roe v. Wade never created, actually created into state law for the 50 years that it spanned? Right? Why were state legislatures content to allow?
Well, that's a really good point.
Right?
And maybe because they became complacent, figuring, it's a federal.
That's my issue. Is you say complacent, and I'm far more cynical. I think this is the gift that kept on giving for these partisan groups that could fund off of protecting, a women's right and bodily autonomy on one side, and then pro-life organizations on this side. That I'm very cynical about that. I think that if there were a unified, common vision, good faith effort to have enshrined Roe v. Wade in state constitutions one way or the other over the last 50 years, we would not be in this situation. This is the most ridiculous recognition of a law that's 150, 170 years old that I've ever seen. Arizona Supreme Court finally gets faced with actually having to go through the weeds and say, no, that was a clear conflict of law, right? We have to reverse that decision based on certain jurisprudential standards. We're not making a moralizing decision. We're not making a decision. We're actually charging legislature for fixing this. And that's all in the opinion. You can go and read, but it's just insane to me. It's insane to me that our politicians all over the country, federal and state level, have been complacent, to use your term, Norm, to allow Roe v. Wade to just be the law when they've had the last 50 years to actually galvanize support.
Well, and I think part of the problem, it goes to what I'll call the spiritual crisis in the United States. At the time states enacted laws such as the 1864 law, we were largely a Christian culture, Judeo-Christian culture. And when I say that, it means that our starting premises and ideas and foundational notions about who we were as a people were scriptural, and we believed in creation. I mean, look at the significance of the Scopes monkey trial in the 1920s, where evolution was challenged in Dayton, Tennessee, in the famous trial pitting Clarence Darrow versus William Jennings Bryan. Darrow lost, but modern science won. At the time these laws were enacted, we believed as a country, and many quite literally biblical fundamentalists, that God literally created humankind, and that he breathed life into us, and so that we were the possessors of the divine. That was our soul, and the most important decision a person could make was was how to orient their soul toward love and obedience to God, or love and obedience to others. Again, to repeat an ancient theme on this podcast, Augustine calls sin love of the wrong thing. So we had a common conception of right rooted in a vision of righteousness inspired in a Judeo-Christian culture. We don't have that anymore. Now we grope for ultimates in other ways, either in expressive individualism, in other words, our identity, in what I will call macabre forms of materialism, efforts to reduce personality to mere complexity, and thus the drive and fear that an artificial intelligence will be able to create something that is not only ourselves, but better than ourselves, and that we may be mastered by our own creation and become a secondary artifact in the evolutionary process of consciousness, that consciousness now being transhuman, as it were. And so I think the abortion debate is untethered. The laws on abortion, Arizona's laws on abortion, are untethered from the Judeo-Christian foundation that they had at one point, and they now lack a foundation. And the result is a public policy that's incoherent. Because if we are simply matter in motion, then there is life at the moment of conception, and taking that life is wrong. If you're going to have laws against taking life, to justify the taking of that life in the matter of a woman's choice, you have to say that life becomes significant at some point. And the imputation of significance on that cellular structure involves a moral judgment that is difficult to make. And so you'll see in Roe versus Wade, the 1973 decision undone by Dobbs, that there was a trimester formulation and a discussion of viability of the fetus. As science pushes the limits further and further back in terms of viability, these limits become unsustainable. And life becomes, in fact, very complex indeed.
Well, and this has become an issue, I think, politically in the modern context. Certainly, Dobbs catalyzed a counter movement, right? And I believe the Republican Party suffered pretty serious losses, at least from an expectation in local and special elections in the months thereafter. Trump made a very clear, he drew a clear line, and I think the pragmatic side of Trump's politics is, I think, the cognitive dissonance that many people on the political right have issues with, and I do think that for all that he's capable of talking about, Cernovich probably has the most nuanced take on all this. I follow him closely when it comes to the issue of abortion, and specifically within the frame of political pragmatism. And I tend to agree with him that Trump has quite skillfully come out publicly and talked about the need for more moderate legislation on this issue, right? Because he recognizes that there is no consensus to be had, and there is no principled position from the political or conservative right that will see them also win politically in a manner that would be significant enough to arbitrage or put in to enshrine whatever they want in their various state constitutions. So it's a tough issue, but again, I go back to just sort of I don't like that as a 34-year-old man that I'm here having a conversation about this when there were 30 years before I came along for polite society to figure out how to not rely on a Supreme Court decision that was subject to change at any given moment, right?
Well, yeah, but I mean, that's that illustrates perfectly the fragile nature of the rule of law. And again, our one of our guiding themes here is that legitimacy is a common conception, not just of common interest, but of right, and that that as a society gropes to come to terms with these ultimate issues under the rule of law, somebody has to be the final decision maker. And in the United States, that final decision maker is the United States Supreme Court. So at one point they had concluded in a manner that satisfied many people. Now that conclusion has been unsettled, and the power to make that decision has been returned to the states. And there's going to be conflict because there is really a struggle about visions of the nature and destiny of humankind. I mean, that's Reinhold Niebuhr's old 2-volume classic, the Nature and Destiny of Man, he being a prominent mid-20th century Protestant theologian. These debates remain fundamental to the American psyche. And it is my view that debates like the abortion debate will force another great awakening in the United States, probably within the next 5 to 10 years.
Sooner than that. And we've seen the likes of Kanye West, who, in the last presidential election cycle was very, was visceral and explicit about his support for the pro-life movement. Right. And so I think that there's a lot going on in American politics, on the populist American politics that have not fully been realized. But there are realignments politically occurring right now that we've never seen before.
And so it goes. We've only talked about 2 of our 3 topics on law and legitimacy because, we like to talk and you like to listen. And we're grateful for your being here. If you haven't had enough of Mike and me, stay tuned on Laid Back Law at Laid Back Law Show. Eric Hunley's become a good friend of the podcast, and Mike and I have been on 3 or 4 times now, and it's sort of become a thing. If we're free on Friday afternoon, we join a panel of other lawyers doing very interesting work around the country to talk about what's going bump in the night. Joe Neerman from Logic, I think, will be on today, I hope, to discuss Trump's trial next week in Manhattan and Joe's efforts on behalf of Logic, to intervene, to undo the gag order on behalf of Trump. I'm sure we'll be talking about OJ there this afternoon. And I'd encourage all of you to listen to at Laid Back Law. It's a Friday afternoon discussion where lawyers come in from around the country to talk about what's hot in the news. Not because we've necessarily handled the cases. Indeed, I don't think there's been a discussion I've participated in yet when we talked about a case we're actually handling. But we give insight from real legal practitioners about issues as they are evolving in real cases that you're learning about, that you're listening to, that you're drawn to for whatever reason. Lately, I've been asking why people are drawn to some cases rather than not. I think other panelists are more intrigued with the legal mechanics of the case. And so, the law is our public effort to resolve our disputes. Lawyers discussing the law can be interesting. And so take a look at Laid Back Law this afternoon. Mike, how do people find us?
You can find us here on YouTube and on X at LawPod Daily. That's one word, LawPod Daily. Please click that follow button, hit the notification bell, subscribe, like, and leave nice comments. Many of you have been leaving really good comments in the last several days on the last several streams. So thank you for those thoughtful comments and really good feedback.
And look, I'm going to tell you folks, that's not my mother. Okay.
Well, yeah. For example,
she died several years ago. So unless it's extraterrestrial communication beyond the grave, which would mean we would have everybody listening, it's other people. So thank you to those other people.
You can also find us on Rumble, Law and Legitimacy. We have great support over on Rumble as well. And that crowd is steadily growing, so never want to ignore you guys, even though I do continue to trash Rumble a little bit. And then if you don't catch us live and in video, you can find our audio only episodes uploaded daily to Spotify, Apple Podcasts, Overcast, Audible, wherever you find podcasts. So Monday through Friday, 8 a.m. Eastern time, and then today at 12 noon at Laid Back Law Show. Nate the lawyer will be there. I think Eric will not be able to be there. I think he'll be on a plane, but we've got a sub as a host. And we've got a small agenda today. So I'm going to try my best to just force in the Las Vegas shooting story as well. To me, a group of lawyers should be talking about that, Norm.
I think we should. We're not immune to the things that we help others with. In fact, we're human, all too human. And the beauty of living long enough is that from time to time you'll stumble, and you're invited at that moment to introspection and to overcome the lawyer's primary sin, the sin of pride, and to acquire a sense of humility about the failings of your clients and your own. All, the good book reminds us, have fallen short of the glory of God, and all are in need of grace. So embrace the grace, and let me end on a graceless note, because you expect me to say it. AMF, yo-yo.
AMF, yo-yo. See you, everybody. See you, Norm.
See you.